It's indeed my pleasure to introduce Judge Michael Nash. You have a treasure here in California, and specifically in Los Angeles County, of having your children's court presided over by someone with such insight and passion, courage, sometimes maybe foolishness, but what the heck. And I think we as a country will benefit from Judge Nash's experience, passion, and courage when he assumes his presidency of the National Organization for Family Court Judges. So it's my pleasure and honor to introduce Judge Michael Nash.
Good morning, everybody. Happy to be here with you to talk about what I think is a very important subject, one that I spend a lot of time in, and all of us in Los Angeles spend a lot of time working on. It's important for every child that we deal with. It's important at the local level, the state level. It's important at the national level. We have folks here from Los Angeles that I work with on a regular basis who know how much emphasis we place on the issue related to children and psychotropic meds in our own county. I'm a judge. I've been a juvenile court judge for almost 24 of my 28 years plus as a judge. I'm sort of a dinosaur when it comes to technology, but I'm at least smart enough to know that it's important and that it can really help us do what we need to do a lot more effectively and efficiently than we do it now, and that particularly applies with respect to psychotropic meds. When I think about psychotropic meds, there are a number of concepts that go through my mind, at least from my perspective. Number one, just the meds themselves. We're talking about the utilization of whole categories of medications for children, and almost all of the medications that we're talking about, there are no studies. They haven't been approved by the FDA, but yet they're used in common practice for children. And they are potentially extremely dangerous. They're also potentially very helpful. But we have to be very careful and diligent about how we utilize these medications on children, and that's why I've spent so much of my time as presiding judge in Los Angeles emphasizing the importance of this issue. The other concept that goes through, and it's also important to note that, well, in Los Angeles alone, we have over 3,000 children under our jurisdiction who are receiving psychotropic medications. I don't know the exact number. The last time I looked, it was 13 to 14% of our children under the jurisdiction of our court. And in Los Angeles, in case you don't know, we currently have over 27,000 children under the jurisdiction of our court. And that's unfortunately the highest number in the country, I believe. But also we know that throughout the state, Judge Bulwer has many children under her watch who are receiving psychotropic medication. We know that throughout the state, the average is probably 13 to 14% from county to county. We also know that there are many studies that show that children in foster care throughout the country, for whatever reason, good, bad, or indifferent, are receiving psychotropic medications at a higher rate than other children. So it's important for us to be aware of that. The other concept that's important for everybody to understand, foundationally here, is the role of the court. And it really starts with the role. When I talk about the role of the court, I'm talking about the role of the juvenile court specifically. And I'm talking about just generally the role of the juvenile court. You know, most judges, from everybody's perspective, are there to decide when they're required to, who did what to whom. We understand that. We also know that judges are the equivalent of umpires in the courtroom. We call balls and strikes. We make sure that the process is working, hopefully, evenly for everybody that's before the court. And that's your traditional role of a judge. Juvenile court judges certainly have that role. But juvenile court judges have been given a much more expanded role within the framework of our juvenile court system. And this role has been given to us by Congress and also by our state legislatures. In other words, what we have in this expanded role is we have an oversight function. We are required to oversee the functioning of the whole system, the child welfare system. We, on a daily basis, have to decide the quantity and the quality of services that are provided or should be provided to children and families. We have to hold agencies that work with children and families accountable for what it is that they're supposed to be doing on behalf of children and families. And this is a very unique role. And in fact, when you look at the standards of judicial administration in California, there's a section that relates to juvenile court judges, and it's entitled The Unique Role of the Juvenile Court Judge. And so we are basically involved with every aspect of this child welfare system from top to bottom. So when people think about judges and the child welfare system, we are an integral part of that system. That system can't work without us. And unless the different parts of the system, specifically the agencies and others, are really working together and coordinating their efforts, the system is not going to work on behalf of children and families. So that oversight role is very important. Now, when it comes to psychotropic medication, in California, and I believe there are some other states as well that fall into this category, we have a very important role in our oversight function with respect to psychotropic medications. The legislature of California has said that judges, believe it or not, judges have to approve the administration of psychotropic medication for children who are involved in our child welfare and our juvenile justice system who have been removed from their family's care. That is an extremely heavy burden. And you know, the last time I looked, I could be wrong about this, but I don't think there are any judges in California, and I don't know of any around the nation, and I have a lot of connections around the nation as the current president of the National Council of Juvenile and Family Court Judges. I don't know that there are any judges on the bench who are psychiatrists or psychologists. I like to tell my colleagues that, or tell people that in Los Angeles, where we have 20 full-time dependency courts and currently 24 full-time delinquency courts, that I'm the only psychiatrist on the bench. But I'm a psychiatrist for my colleagues. They come in and they sit on my couch and they tell me all their problems, and I give them the best advice, you know. Go home, take 2 aspirin, and come back tomorrow and try it again. And in fact, a few years ago, believe it or not, we had a judge in Los Angeles who is actually he's still on the bench. He's a licensed pharmacist, and he was assigned to the juvenile court. And here's one of those situations where a little bit of knowledge could be dangerous. He refused to approve any request for psychotropic medication for children because, as I pointed out at the beginning, they've not been approved by the FDA. There haven't been studies on every one of these medications for children. He says, I'm not approving it for these little kids. In a way, I can't blame him, but we had to get rid of him because our court psychiatrist said, look, you have to understand that these medications are utilized commonly in practice for treatment of children with the issues that we have to deal with. I see Jim Owens back there laughing. He knows who Jim Owens, county council in LA, knows who I'm talking about from a few years ago. But this is a very important role that we have, and as I hope you'll understand as I talk a little bit more that even though we're not psychiatrists or psychologists, there are very discrete functions that we have vis-a-vis these medications before we sign them or approve them. And I can't speak for other counties. I know different counties do things differently. Fortunately, in Los Angeles, we have a partnership with our Department of Mental Health. Our Department of Mental Health actually has created a team of psychiatrists and psychologists called the Juvenile Court Mental Health Services Unit, and their primary function is to review all of the requests for psychotropic medication that we receive for children, and they will tell us or make a recommendation to us based upon the statewide form that we use as to whether or not we should approve or deny the request for medication. And they will basically tell us whether, based upon the symptoms described in the documentation we receive, that whether or not this medication is medically appropriate. But once again, our job is not simply to rubber stamp the recommendation that we receive from the Department of Mental Health. And this is one of these areas where, once again, the lack of technology really comes into focus here. Our Department of Mental Health generally just reviews the form. And I think you have a copy of the form, and I saw it in some of the materials, the JV 220 form that physicians send in when they want to get approval for a medication. Once again, they review that form. They do not necessarily have access to the complete file on the child. I do have a copy of, I have the file, and I know much of the history of the child that's in that form. So it's important for me as a judge to, number one, make sure that the form has been filled out, and number two, I have to make sure that that information on the form is accurate. There may be information on that form that raises a lot of questions that our reviewing psychiatrist is unaware of. Simple example. On a number of occasions, I've gotten a request for Ritalin for treatment for ADHD, very common, and the form will describe the different symptoms that the child is exhibiting, and typically those are your classic ADHD symptoms: can't sit still in class, can't focus, this, that, and the other. And once again, I have the court file in front of me. I have probably had this children like this on my docket over the years, and it's important that I review that file, and I review the reports that we receive from the schools, that we receive from the social workers, to make sure that that is actually reflected in there, that kind of behavior. And I've seen cases where I've gotten the request with these symptoms described that are completely opposite of the information that I have in the court file. So in that situation, I'm certainly not going to approve that medication without further investigation. And that's a very important function that the court that plays within the framework of this process. Now, the process itself, really raises many, many, many issues. We generally are concerned with and over the years have been concerned with the approval process. What are we approving? Why are we approving it? Who's recommending it? What are the qualifications of the persons that are recommending the medication? What else? Has the child been informed of the side effects? What's the child's attitude towards the medication? Are there other types of therapy that are being used in conjunction with the therapy? Are there other types of therapies that can be utilized in lieu of the medication? Has that even been considered? And this is the kind of information that we need to receive before we approve the medication. And then once we actually approve the medication, the question then becomes, who's going to monitor the medication? Who's going to monitor the effect of the medication? Who's going to make sure the child even receives the medication? There are no rules regarding that. In fact, a few years ago, there was legislation that was approved by a wide margin in this state that basically said that when the court approves psychotropic medication for a child under its jurisdiction, that there also has to be a defined monitoring plan in place. And that legislation was vetoed by our previous governor. And on a certain level, I could understand that, because one of his reasons was that, hey, if you're going to approve this medication, it makes sense that you're going to monitor the effect of the medication. Do we need a statute to tell you to monitor the effect of the medication once we've approved it? But the fact of the matter is, the reason that bill was enacted was the fear, I think a legitimate fear, that for the most part, when there was appropriate monitoring, it was the exception rather than the rule. So another issue for us with the medication is that we have to have some sort of a formal process in place to ensure that, number one, the child receiving the medication, and what is the effect of the medication? Is it having a positive impact on the child? Are there side effects that we ought to know about, or that somebody ought to know about? Is the child being regularly monitored by the physician who prescribed the medication, or at least somebody else who's familiar with the child, who's familiar with the issues that the child has, who's familiar with the utilization of the medication? Another issue that, once again, we have attempted to address in Los Angeles relates to one of the major banes of our existence in child welfare. As you know, placement stability is often lacking. Children within the framework of our system move from placement to placement to placement way too often. So what happens? What happens when a child moves? What happens when a child is taking medication moves? Is the medication moving along with the child? Because we know that when a child is receiving a medication, if you interrupt that medication regimen, it can have a very negative impact on that child. So once again, we've had to create processes to ensure that the medication is moving with the child. Also, more and more youth over the years and currently are aging up and out of our system. They reach the age of 18, and at that age, the court no longer has the authority to approve the medications for children. They're on their own. They're adults. They can make these decisions for themselves. And so the question for us becomes, what are we doing as a system to engage the youth at an early point in time in this process, utilizing medication that prepares them to make these decisions for themselves when they reach the age of majority? We know that study after study has shown that youth who, what we used to call emancipate from our system, it's a bad word, we say they transition out, they age out. We know that the outcomes for these youth have generally been negative. And I've always wondered, how many of those negative outcomes are impacted by the fact that we're talking about youth who, while in the system, were receiving psychotropic medications, and when they left the system for whatever reason, the medication stopped. Also, issues that are important to us. What are we doing to prepare caregivers who are taking care of these kids who are receiving medication? Do they have the wherewithal to obtain the medication? Do they know how to administer the medication? Are they trained what to look for in terms of side effects and so forth? And what about parents to whom we're returning children? What are we doing to prepare them in the event we're talking about a child who was not previously taking medication before the child was taken into custody in our system? So there are numerous issues with respect to psychotropic medication that we need to be concerned with. And within the framework of our systems, we have all these players. We have the court, we have social workers, we have probation officers, we have attorneys who represent kids, we have CASA volunteers who are assigned to work with kids. Of course, we have the parents, the caregivers. We have the prescribing physicians. We have perhaps other professionals that are assisting the court in making the decisions that we need to make. And of course, now there is a statewide rule pending, which I think is appropriate, that says we have to involve the Indian tribe in the process when we have children who are members of Indian tribes who are under our jurisdiction as well. So how do we communicate all that? How do we keep everybody on the same page when essentially what we have is a system that's operating with the movement of paper? And the paper that people receive may not be the same. We have in Los Angeles, we have our Department of Children and Family Services that keeps some sort of record. I'm not even sure what it is, okay? They very rarely even provide us with input. We have our own Department of Mental Health that assists us, that keeps some sort of record. At least they have been for the past few years. Those records, they don't intersect with each other. We have these forms that are required by the state that come through that come to us generally through faxes, occasionally through email. We have the court receiving paper at the end of all this, and hopefully people are following their obligations and segregating it within the court file so that we can refer back to these as we get new requests for medication and so forth. It's a very, very rudimentary process to deal with very, very important issues. And so the question of, or the issue of providing adequate technology that tracks all this, that keeps us all on the same page, is very important. And it's very important not only to us working here in California who have this, particularly judges who have this obligation. I believe it's the obligation of judges throughout the country. As president of the National Council of Juvenile and Family Court Judges, after talking to folks in Congress in talking to folks in the Administration for Children and Families about this issue, we created a psychotropic medications committee within the National Council so that we can develop what I believe are appropriate standards that clearly articulate the role of the judge vis-a-vis this particular issue. And we're currently working on that. Hopefully we're going to have something that we will publish within the next few months, but it really mirrors much of what I've been talking about here today. So I think my time is up, but I hope that I have at least expressed in some meager way the importance of this issue for all of us who work with children within the framework of our systems.
Thank you, Judge Nash. I've been looking for a psychiatrist on the West Coast, so I might want to see you later. I want to bring you back to yesterday and the proof of concept. In the next 10 or 15 minutes, we're going to again I want to remind you what this proof of concept is and go back to Judge Nash's comments and the earlier comments by Sarah about where to get the best information from the best source and bring that information to the people who need it in a timely manner. So this proof of concept is just one example. So I want to again say this interoperability grant is not about child welfare. It is about interoperability of health and human services in California, which is huge. Not only from a state perspective, but then the implications throughout all the counties, through the private providers in the counties, and of course our partners in different areas, the courts for child welfare, the doctors just for medical care. And so we're taking an example and taking it from a concept to a proof of concept. So we could have picked other examples, but it really wasn't a choice. The Psychotropic Administration, the administration of psychotropic medication for children in foster care is one of the audacious goals of the California Health Information Exchange. So it was just a natural process to select that as our proof of concept. So in this chart that's beautiful, except in this projector, with bright yellow and bright green, this looks like it went through the wash and got, all the colors got mixed. But our data set is there. It's the forms that the court has already ordered needs to be provided to the court. Our process is not to say to the judge, we're taking your job. This process is to say we're going to try to give you as much and best information to make that decision. Which it's still the judicial decision as to whether to grant or deny the request. Judge Nash did remind me, putting on a child welfare hat for a second, of one of Commissioner Brian Samuel's favorite statement about psychotropic medication for children in state care. He calls it the 3 2s. Too many medications are prescribed at the same time for the same child. Too high of dosage of these medications and prescribed for too young of children. And so this proof of concept won't prove one way or another those 3 2s, but it will give as complete information as possible to the county social worker, to the physician, and to the court by by proving and showing interoperability in the Child Welfare Statewide Data System, CWS-CMS, by the state's meds system, which is for what medications have been prescribed and paid for this child in the past, and from the doctor's electronic health record information. And it will populate electronically onto these forms so that hopefully you get the best information and the county social worker doesn't have to do it manually. The doctor or the doctor's office doesn't have to do it manually. And we've also connected with the state Medicaid system. So this proof of concept will be reusable in other counties, and the state will be able to build on this when connecting all the health and human services in their interoperability plan.